Hello students, welcome to KANISHKA IAS. Today we are going to discuss what are the Supreme Court guidelines in a recent PAL regarding the implementation of the Right to Information Act, especially with respect to appointment of CIC and SICs. Actually, when Ambedkar was asked about the effectiveness of the constitution which the Constituent Assembly had enacted, Ambedkar has answered that the success of the constitution not just depends upon the content of the constitution, rather the people who man the institutions. This particular answer of the Dr. B.R. Ambedkar is rightly suitable in the case of the implementation of the Right to Information Act. In fact, right to information is not a fundamental right, but the Supreme Court in Indira Gandhi versus Raj Narayan held that right to information also falls under the freedom of speech and expression, that is Article 19 Class 1 Subclass A. And later, the Parliament has enacted a legislation, that is Right to Information Act of 2005, which has given the legal status to the fundamental right, that is interpreted by the Supreme Court. Okay, so but right from 2005, we can see different phases or different scenarios for the implementation of the Right to Information Act. In fact, the 2019, which is the landmark year, which has made the Right to Information Act very much ineffective. Why? Because in 2019, an amendment was made to Right to Information Act where the appointment of the Central Information Commission completely went into the favor of the central government itself. Not only CIC but also the SIC. Both CIC and SIC are statutory bodies created under the Act to ensure the better implementation of the Right to Information Act. In fact, the SICs and CICs, okay, the Central Information Commission and State Information Commission, have to act in the independent manner, not becoming loyal to the executive. But of late, what is happening? The CIC and SIC are becoming subordinate to the respective executives. So there are various reasons, okay, for that kind of political partisanship. The Supreme Court in Anjali Bharadwaj versus Union of India case has given a detailed guidelines how to ensure the better functioning of the Central Information Commission and State Information Commissions. Why? Because it has said that the both Central Information and State Information Commission shall not be dominated by the bureaucrats, rather there must be diversity in the appointment process. There must be different walks of lives must be represented in the SIC and CIC. That was the direction. And moreover, there must be timely appointment of the members in the Central Information Commission and State Information Commissions. In fact, the Right to Information Act is the right direction, or it is a step in the right direction for the effectuating the good governance. Because good governance means what? Making the administration and governance people-centric and ensuring the proper information accessibility to the people to monitor how the government is functioning. But unfortunately, because of non-implementation of the Right to Information Act and because of the non-appointment or untimely appointment of the information commissions and politicization of the appointment process, is making the implementation of the Right to Information and good governance very much difficult. The Supreme Court in the recent case has noticed certain important things. That is, first important thing is, under Right to Information Act there is Section 4. The Section 4 mandates that the information which is frequently asked by the people or any citizen, that must be proactively disclosed by the government. That must be proactively disclosed by the government. But unfortunately, government is not going with the proactive disclosure. Because of this reason, 40% of the information that is sought from the Right to Information Act, that is supposed to be disclosed proactively by the government. So this is causing huge pendency in the Right to Information Act implementation. Okay, and moreover, if you try to look at the Central Information Commission, it should have ideally the strength of 10 members, but instead of 10 members, there is only 3 members working presently. So it means the present composition, the present working of the Information Commissions is completely in a difficult phase. And even sometimes the Information Commissions are not dealing with the pendencies with the required pace because of the politicization of the appointments. And apart from that, the 2019 amendment of the Right to Information Act de-equated the Information Commissions with the Election Commission. So de-equation means earlier these were statutory bodies only, but still because of their equation with the Election Commission, they got requisite powers and requisite prestige and status in the government, so that every department has to abide by the directions given by the information commissions. Now the removal or service conditions are completely vested with the executive. Okay, that means service conditions means which will explain how the salary, leave and disciplinary actions shall be taken. These are all to be determined by the government, central government, time to time, because of the amendment which was made in the 2019. So this is all making the good governance a very, very difficult process in the country, because the effective implementation of the Right to Information Act itself creates the proper ecosystem, creates a proper platform for the people to ensure their aspirations, their requirements are reflected in the policy making. For instance, if the people are asking the information so repeatedly, it does indicate that there is a problem in the public policy. Or if the people are trying to ask something, or if the people are trying to petitioning the government something, and they want to know what is the status of that petition, that is also is having the direct impact on the administration. So that administration will be made answerable to the people because of the Right to Information Act. And Right to Information Act itself is the feeding aspect for the Whistleblowers Protection Act, Lokpal, Lokayukta, prevention of corruption. So if you don't implement the Right to Information Act effectively, the effectiveness of the other legislations will also be at the compromise. Okay, that's why the Supreme Court guidelines in the recent PAL is very important to ensure the proper implementation of the Right to Information Act. Even there are various Supreme Court judgments earlier. For example, in PUCL versus Union of India case, in which Supreme Court held that right to information is a fundamental right. And apart from that, the Supreme Court in Subhash Chandra Agarwal case, Subhash Chandra Agarwal versus Supreme Court Secretary General, in that case also, Supreme Court brought itself under the ambit of the Right to Information. So we can understand the importance of the Right to Information Act through various judgments and various guidelines given by the Supreme Court. Thank you.